Yes, respected brothers and sisters. This is Advocate Prabhudas Devmorari from Ahmedabad city, Gujarat state, India, that is Bharat. Today I have selected a very good running topic touching to all the people. The sexual harassment of working women at workplace. The protection against sexual harassment and the right to work with dignity are universally recognized human rights. Sexual harassment at workplace is considered a violation of women's right to equality, life, and liberty. The Constitution of India embodies the concept of equality under Article 14 and 15 and prohibits discrimination on grounds of religion, race, caste, sex, and place of birth, or any of them. Article 19 in bracket 1 in bracket G gives a fundamental rights to all citizens to practice any profession or to carry on any occupation, trade, or business. This right presupposes the availability of an enabling environment for work which is equitous, safe, and secure in every aspect. Article 21 relates to the right to life and personal liberty, includes the right to live with dignity. And in the case of women, it means that women must be treated with due respect, decency, and dignity. These three words are very important. Due respect, decency, and dignity at the workplace. Now, the point is, what is sexual harassment? What do we mean by that? Sexual harassment includes any one or more of the following unwelcome acts of behavior, whether directly or by implication, namely physical contact and advances, or a demand or request for sexual favor, or making sexually colored remarks, or showing pornography, or any other unwelcome physical, verbal, or non-verbal conduct of sexual nature. Section 3 of the Act provides that the following circumstances, among other circumstances, if it occurs, or is present in relation to or connected with any act or behavior of sexual harassment, may amount to sexual harassment. For example, implied or overt promise of preferential treatment in her employment, or implied or overt threat of detrimental treatment in her employment, implied or overt threat about her present or future employment status, or conduct of any person which interferes with her work or creates an intimidating or offensive or hostile work environment for her, or humiliating conduct constituting health and safety problems for her. Now, if this happens, then you can lodge a complaint under Section 26 before Metropolitan Magistrate or Judicial Magistrate of first class. Any agreed woman can make a complaint to the Metropolitan Magistrate. Now, as per Section 16 of the Act, prohibition of publication or making known the contents of complaint and inquiry proceedings. Contents of your complaint can never be published, or even inquiry proceedings can never be published. It should remain in secret. And the most important is, cannot be given judgment because there is a specific bar provided under Section 16 of the Act. Then what should be named in judgment? Courts should refer complaint as X, not name. Only one judgment is there, 2017 in bracket 4 All LJ Allahabad Journal, Law Journal 51 in bracket 16. Alternative 2017 in bracket 4. ADJ 715 DB. The name of this law is the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. Now the next point is also important. Section 15, determination of compensation. Any aggrieved woman can get compensation. Now what are the factors affecting for consideration? This clause provides for determination of compensation. It provides that for the purpose of determining the compensation to be paid to the aggrieved woman, the internal committee or the local committee shall have regard to. Now, what are the factors to be considered while determining compensation? The mental trauma, pain, suffering, and emotional distress caused to the aggrieved woman. The loss in the career opportunity due to the incident of sexual harassment. Medical expenses incurred by the victim for physical or psychiatric treatment. Income and financial status of the respondent. Respondent means opposite party, accused. Feasibility of such payment in lump sum or in installments. Now, what are the duties of the employer to avoid such problems? It is given in Section 19 of the Act. Section 19 lays down duties of the employer. It provides that every employer shall provide a safe working environment at the workplace, which shall include safety from the persons coming into contact at the workplace. Next, display the order constituting the internal committee at any conspicuous place in the workplace. Next, undertake workshops and training programs at regular intervals for sensitizing the employees regarding the provisions of the proposed legislation. Provide necessary facilities to the internal committee or the local committee, as the case may be, for deciding with the complaint and conducting inquiry. Or next, assist in securing the attendance of respondent and witness before the internal committee or the local committee, as the case may be. Make available such information to the internal committee or the local committee as it may require, having regard to the complaint. Provide assistance to the woman if so chooses to file a complaint in relation to offence under the Indian Penal Code, IP Section 409, or any other law for the time being. Now, at present, Indian Penal Code is replaced by Bharatiya Nyaya Sanhita 2023, in short it is called BNSS Section 79. Initiate action under the Indian Penal Code or any other law for the time being in force. Happened in Maharashtra, Nasik and other things about working women. It came in the newspaper also. That tempted me to make this video. So, this is the end of the video. Please like it, share it, and subscribe if you want it. Thank you very much for patient hearing. See you in the next video. Thank you very much.